is a rule of gray area. You know, you have your interpretation, we have our interpretation, and
yeah, but
they're both is a plausible.
No,
both of these things are a plausible rule in which these various things come to be. And that means there's nothing more to talk about after our discovery tomorrow.
That's patently false. I mean, you have there's a threshold standard for lawyers. What would the average lawyer look at this? If you're one lawyer looking at it this way and the other 99.9% look at it the other way, that you can't say it's a gray area when a logical or a prudent man wouldn't look at it that way. I mean, you're looking at things. I mean, Andy never texted me that, so that should be admitted. He never texted me that. Clear as day, there's no text that says that. So I don't
and that's why it's qualified.
Yeah, but the qualification, I mean, that's legitimately the biggest stretch of all time, considering I was very, very clear why I wasn't closing. Your original complaint is founded on that one text right there. Your original complaint. The only evidence, you didn't put any evidence of an eviction or any text of that. All you had was affidavits, and you pointed to this one text that does not exist. So I was very, very clear at why I wasn't closing. I stated things over and over again. So when he said, the reason I'm not closing is because I wanted to sell to someone else for more money, and in your complaint it says there's a text that alludes to that, I mean, that's crazy to think that's not false. I mean, I don't see how any way you can twist it to make it work with your, and regardless, your facts completely change in your motion to dissolve hearing. So, all right, if that's
this is the nature of learning, of discovering as we go. You know, we work with what we have when we have.
Yeah, but we both have to be honest. We both have to be honest, and we both have to actually look at these in a logical manner. There's nothing logical about your position.
I'm sorry that you feel that way.
It's not a feeling. I mean, this is just it's simple. I mean, I don't see anybody that could look at this.
It's your belief. Well, and you've asked the judge to do just that, to look at it and conclude that we're wrong. And so your summary judgment motion will do just that.
Okay. Let's see.
Isn't that what this process is for? You don't need to convince me. You need to convince the court.
Yeah, but during discovery, it shouldn't be a one-sided discovery where I'm just sending you everything I have, and then I'm literally clawing just to get you to admit to the most basic of things that are, you know.
Why would we admit to something that we disagree with?
Because
we disagree.
No. That's not disagreeing. That's not disagreeing. That's literally just manipulating facts. That's not.
No, we believe you are manipulating facts.
How?
Or mischaracterization.
Tell me how. Tell me how I'm manipulating facts.
We've qualified it to explain our answer.
Tell me how I'm manipulating facts. I've yet to hear.
This has anything to do with discovery. So tell me about your next discovery concern.
I've yet to hear one thing that you've refuted of mine, or how I've twisted facts, how I've done anything of the like. So,
that's because I'm saving those issues to present to the court, because I don't need to convince you of my case. I only need to convince the judge of my case. And so I'm going to do that. I don't need to prove to you that you're wrong. I need to prove to the judge that you're wrong. So we're going to have that conversation with the court. I don't need to have that conversation with you, so I'm not having it with you. I'm willing to give you the time you need if you want to have that conversation with me, but you're not going to persuade me otherwise.
I'm not going to persuade you to tell me where I'm wrong when, I don't see why if you had an actual...
You're not going to persuade me that we have a different take on the facts that you've cited. And ultimately, I don't believe that any of these facts that we're talking about have any bearing, ultimately change the outcome of the case. So this meeting is for the purpose of discussing discovery procedure.
Yeah.
Objections that you feel were inappropriate, or responses that you feel were incomplete. So I welcome.
I'll keep going.
Let's talk about the objections and responses.